Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, and welcome to the program. My name is Justice Maduforo. I'm a solicitor and the principal of Tice Madox Solicitors. I'm also a barrister. This program brings the very best for you, and as you all know, I've discussed on this program so many topics, ranging from immigration to employment, to criminal, to immigration, and to civil litigations as well, contract. And these are key strong areas. And the essence of this is to kickstart your consciousness, as you know. This is not a legal advice program, but to kickstart your consciousness so that you can take the right step. And it supposes you to Tice Madox Solicitors where you can get the right advice that you need. Now, some of you may think, oh, I can get the advice that I need over the internet. But that is not specifically what it is when you consult an expert on a face-to-face detailed basis, because your circumstances will be taken into consideration. They'll never be the same. But nonetheless, you may try, and as most of you do, by the end of the day, you resort back to the right position and the right step we should take, which is to give proper instruction to your advocate and to your solicitor who can properly advise you and tailor-made your circumstance to fit into the issues. Ladies and gentlemen, this program is the very best you need. So discussions on this program, they are not legal advice. Therefore, you must not act on them, but you must consult us, advise, for us to advise you and take the matter forward. So details on the screen, as you can see. Today, I'll be discussing on civil litigation. My topic is civil litigation pre-action protocol. Civil litigation pre-action protocol. Why do I say so? Obviously, stopping there, first of all, as you know, this firm also has a criminal legal aid franchise to represent you in police station free of charge, to the Magistrates Court, to the Crown Court, High Court, Court of Appeal, Supreme Court, free of charge, subject to means testing from the Magistrate Court upgoing. So in all serious areas that you face, from issues of fraud down to the lowest matter of common assault, this firm will represent you effectively both in litigation, advocacy, and court. So you must bear that in mind. So if you say to yourself, I don't really need a solicitor, that is a wrong perspective. It's a wrong narrative. Some of you run with this wrong narrative by saying, I don't need a solicitor. As long as you are in this country, you do. You may not at the moment, as a matter of fact, but clearly your daily activities build up to the fact that you will need a solicitor along the way. And it's just like someone saying, I don't need a doctor, or saying, I don't need a builder. You may not need a builder or a doctor because you're healthy now, but I can tell you it's important that you understand what the builder or the doctor will do for you at the time you need them. Or it may not be you specifically needing this right now. It may be someone you love, or someone you care for, or someone you know, or someone who've asked you, I said, I need the right solicitor to advise me on this. Then that's the point that you signpost them to Tice Madox Solicitors. So I'm discussing today civil litigation, and the topic is pre-action protocol. Now, civil litigations are matters that lead away from criminal matters. So we call them civil litigations. Matters that are not criminal in nature goes to civil litigation. And some of them that are civil litigation matters that are dealt with in the magistrate court, but in stricter sense, so they are not criminal proceedings, but guided under the civil proceedings or procedures. So civil litigations are away from criminal proceedings. Sometimes also employment matters or immigration matters, some can class it as civil proceedings, but they are not civil proceedings per se. So they are immigration proceedings and they're also employment proceedings because they are guided under a different procedures. So civil procedures or civil litigation is guided under the civil procedure rules. The civil procedure rules guide civil litigation. Now, why do I mean by pre-action protocol? You know, when you want to commence an action against someone, against a company, against anybody that has a legal entity surrounding them, not action against someone who is not a legal entity, but someone or an individual or a company or a corporate organization that's a legal entity. That's a very important fundamental basis. And then the civil procedure guides you on how to commence the claim. and not just have to commence the claim, as when some of you lodge your claim form in the county court or in the high court. The civil litigation provides for what is called pre-action protocol. Now, pre-action protocol is very key. Now, listen, when I represent clients, especially taking your matter from the beginning, having consulted with you and having now advised you, number one, I understand the strength of your case, advise on the strength of your case. I also advise on the chances of success in that civil litigation. And all that encompassing will enable you to know whether you have a good case running forward. Some of you run very blindly by running straight to the county court to lodge a claim against someone. And it happens that within the half span of that proceedings, you find that it's a baseless claim, or you find that you're losing the claim. And not just that, you find yourself a cost against you. And these costs are very huge, and they spiral out of control quickly. From a cost against you, and you refuse to pay it, and the other party whose favor the cost has been awarded will take you up. And they sometimes lead to bankruptcy. And for just something that you just ignited. So it's important that you know that there are divisions of labor or divisions of expertise. And so therefore, certain things you think you can do for yourself, you can avert catastrophic outcome by going to the right channel that can take it up from you. Now, pre-action protocols are not meant to be cumbersome. Pre-action protocols are meant to be commercial in sense, are meant to be resolutions quickly, to resolve the dispute quickly. They're also to put price and cost down and almost non-existent. They're also to ensure that the issues are in your case, in your claim, are laid bare and with documentations provided to make your claim much more easy to understand from the defendant point of view or respondent point of view, and to ensure that enough negotiation and enough agreement is entered into, enough disclosure is entered into before you lodge your claim form. Now, to those who understand pre-action protocol, it's always an advantage for your client. Tice Madox Solicitors understand pre-action protocol tool. And when we use this tool, it achieves you the great same purpose that you seek by just going to the county court or to the high court civil division or to the Court of Appeal civil division to lodge your claim. But however, some have argued also in terms of the chances of success in pre-action protocols. Some people have argued on the basis that the other party want to refuse to admit liability. And on that basis, what that leaves the other party is to commence proceedings. Now, one thing is clear, that once you have established pre-action protocol, number one, your case is clear. A clear-cut issues have been introduced into that claim. And that claim is what you can rely on. That action protocol detail becomes your Bible. It becomes the template. It becomes the guidance to rule and to run with that claim form and that claim. So that claim, that action protocol will set forth your claim, your cost, what you are seeking for, how much you want from the other party, what are the remedies you are seeking from that party, alternatives to the remedies you seek from the other party, because it's not just saying on one straight expressway there's demand, I want you to pay me so amount of money. No, it may not be in terms of a financial remedy. There are other alternatives which will also at the end of the day translate into financial remedy for you, even if it's not physically financed. So this is left for those who understand the rudiments, the intricacies, the procedures, the values of how it takes to run civil litigation and civil litigation in the county court, in the high court, especially if your matter is a high value claim or even moderate value claim. And even, to some extent, very, very low value claim. And in that circumstance, you go to the small claim track. Now, the small claim tracks in the county court or thereabout, to some of you, is a small claim track. But the extent it takes you to run this trial, to run this hearing, from the pre-trial review to the case management hearing, to the disclosures and standard disclosures, the other parties, each party have to abide, and then to the main hearing, a trial itself, whether it is set for 3-hour trial, 4-hour trial, 1-day trial, it is quite enough. But however, as I said, a commercial thinking client, firm, and a commercial thinking advocate, and a commercial thinking solicitor from the beginning, which, as a matter of fact, what Tice Madox Solicitors will offer you, is to start from the beginning, ab initio, to make sure that in introducing pre-action protocol, that these matters are settled before you go into the hearing. That is the essence of introducing pre-action protocol hearing. Now, there are consequences of not obeying or following the pre-action protocol guidance and rules provided by the civil procedure rules. The civil procedure rules, by the way, has changed and evolved over years with some changes, amendments introduced into it as a result of case laws up to the Supreme Court of record decisions. So that have affected the civil procedure rules and introduction of certain cases, introduction of certain very much adamant and redundant procedures, which is no longer effective in the modern age, a modern time. So the civil procedure rules have been amended over time to reflect on things that are really reasonable, things that are really, proportionate, things that are, justiciable as well. So introduce them into the civil procedure rules, which guides civil proceedings anyway. So without the civil procedure rules, you cannot operate the civil litigation in the county court and the high court or thereabout, or even the Court of Appeal civil division. So the essence of the civil procedure rules is to guide parties and to make sure parties follow this. It's meant to be neutral, not against any party, either your applicant or your claimant or your defendant or respondent. It does not matter. It's to guide parties to make sure that fairness is achieved at the end of that case. Fairness is achieved. So fairness starts from the pre-action protocol, by the way. By the time you prepare your case, prepare your facts, prepare the argument you have, for or against, then the other party will want to accept liability. Even if the other party don't accept liability through the introduction of a pre-action protocol, the other party may want to accept remedy, accept to remedy the situation, but denying liability. Because once you admit liability, obviously it has its own repercussions going forward. This particular topic is very crucial and germane to some of you who are litigants in person. Litigants in person are actually catastrophically destroying themselves. Whether they have reasons of lack of funds, by embarking on the long journey of litigation which they know not. The rules of civil procedure rules cannot be changed or cannot be watered down because you're litigating in person. It cannot be removed because you're litigating in person. The more you tell the court, I don't understand this, I'm not a lawyer, that is much more the law. The court will tell you this is the laid down rules, and therefore you can't change it. And then why do you want to embark on the journey where you want to seek justice, you want to seek, completion, you want to seek conclusion in your matter, and you're running by yourself where there is a rules that provides where you embarked on, and you don't know the rules, you can't follow the rules, and instead you keep making demands and excuses in court. These judges are trained to understand that litigating persons sometimes become a clog in the wheel of justice. What means is that they continue to bring in matters that does not aid proceedings. And so sometimes these judges would depend on whether your case is assigned to a particular judge or is being distributed to different judges at different hearings. But at the end of the day, the orders of this court will continue to reflect to the final disposal of your claim. And if your final disposal of a claim with the orders of the court has found you compliance with the orders, not compliance with the CPR, which is the civil procedure rules, procedures, and directions, and you have not complied with the practice directions as it guides, and it is stipulated to guide civil litigation. And the court found at the end of the day you have not complied with it, there are consequences of that. Now, the most important thing here, when we talk about pre-action protocol, the civil procedure rules have provided certain cases whereby pre-action protocol must underline boldly in capital red letters, must be complied with. There are so many areas in civil procedure rules that provide for that. Now, the professional negligence claims must be proceeded first with pre-action protocol. Now, judicial reviews, as some of you always embark in the immigration hearings and immigration cases, must be complied with. There are other areas, medical negligence claims you must comply with. There are quite a lot of the provided rules whereby before you embark on that claim, you must comply with the pre-action protocol. Pre-action protocols are very crucial, which the court finds it absolutely disrespectful of the court proceedings and court rules. If you are litigating in person, is embarking on that and go straight to lodge your claim without first of all furnishing pre-action protocol. The essence of this pre-action protocol is make sure that, number one, the other party understood clearly your claim, understood clearly what your issues are, understood clearly what the evidence you're introducing to backup your claim is. Understood clearly what are your remedy you seek. To understand clearly the chances of your success if this matter goes forward. To understand clearly exactly the liabilities that lie on the defendant or the respondent. Then in that case, the other party will enter into negotiation. The essence of it is to divert straightforward claim out from the court and not wasting the court's time and not accumulating unnecessary costs against you or the other party. Therefore, you can be able to know the issue. Then issues are narrowed down. By the time both of the parties refuse to accept liability or accept disposal of the claim, then the court will adjudicate on clear-cut issues. Clear-cut issues that does not clog up the court's time. That's very important. Now, failing to do that or failure to comply with that has the consequences for the claimant who commenced this claim in these provisions. And if they fail to comply with this, has its consequences. Consequences, one of them is the cost. Consequences of part of that is actually an application to strike off your claim. The other party, which is the defendant or respondent, if they are very alert and alive to their claim or to the defense, and they could be able to bring forth what is called an application to strike off your claim from the ab initio, from the beginning, for failure to comply with the pre-action protocol that is required and is laid down. Sometimes the county court or the high court may not strike out completely, but if the application for strike off is well made out, in the sense that the documentations to show the claim that you have against the defendant or respondent is not succinctly and appropriately and clearly and legibly put forward, then in that case, the defendant has no other choice but to say, I do not understand the claim against us. And therefore, it is not in interest of justice, it is abuse of court process, or whatever the position is, you have not laid claim, you have not laid bare and explicitly clear what you claim against the other party. Or rather, what you claim from the other party, it is not actionable. There are certain cases that are not actionable. There are certain causes that are not actionable. There are certain claims that are not actionable. There are certain circumstances that are not actionable. But if you continue and lodge your claim because you're litigating in person, or that you've gone to the wrong firm, a wrong solicitor or advocate who has gone further because either way to please you and gone further to lodge a claim for you, and it has their own consequences. Sometimes these firms could get what is called wasted cost order against the firm, knowing clearly well that the claim they bring before the court is absolutely a waste of time. It's not actionable at all. It has discloses no case whatsoever for the other party to enter into a defense, so the court can actually, in the real sense, strike off that claim and order a wasted cost against the solicitor, sometimes against the solicitor, not even you who is the litigant, sometimes against you if you're a litigant in person. That means, what I mean by litigant in person means you yourself representing yourself. Then the court can order that. Now, pre-action protocol is a cushion to deal with matters and to put cases in better perspective. Pre-action protocols are important. Now, there are two types of pre-action protocol compliance. Now, the ones are provided by the civil procedure rules are clearly dated. As I mentioned, a few more of them, matters of medical negligence, professional negligence, clinical negligence, judicial review proceedings, in any judicial review proceedings at all, be it in immigration tribunal, be it in the civil procedures, be it in anywhere, in high court, or even the criminal proceedings. Those ones must be complied with stricto sensu, which means strictly provided for. Now, there are also what is called provided by the civil procedure rules, but no longer as stated clearly within these case laws. The practice direction of the civil procedure rules provide for what is called pre-action conduct. Pre-action conduct. What are pre-action conduct? This pre-action protocol is different from the pre-action conduct. In certain cases, in certain claims, or the claim for money, for instance, that you claim money for the other party, or the landlord claiming money from the tenant, or contractual disputes between two parties, and what they're claiming is money, or what they're claiming for a specific performance, or what they're claiming is for amendment, or what they're claiming is for a compliance with one of the procedures or the clauses in the contract or thereabout. And so whatever it is, those are provided by the practice direction, pre-action conduct. Pre-action conduct are very crucial. They may not have the same consequences or carry the same consequences as non-compliance with the pre-action protocol provided by the civil procedure rules. But however, when a party fails to comply with pre-action conduct, which leads to a proper litigation commencing and proceeding, The other party may still come back to apply to the court and to strike off on the basis that there is no case being established. The essence of the pre-action conduct or pre-action protocol is to basically put forward the issues, see whether they're justiciable, see whether they are actionable, see whether they carry a force of chance of success, see whether they can withhold the scrutiny of civil procedures, whether they can stand the threshold which is beyond, on the probability of balance, or balance of probability, as it may be. So these are the advantages of pre-action conduct or pre-action protocol. And one of them, which is the pre-action protocol, it has an adverse effect provided by the civil procedure rules. But pre-action conduct also provided for, it is in the interest of the claimant to comply with that. Then it can test the water and see the response from the other party and see whether the case can be concluded. Listen, let me tell you this. I think it's important I say this. In Tice Madox Solicitors, myself, a solicitor and also a barrister for years with years of bags of experience in the cases I discuss on this program, be it criminal, be it family, be it immigration, be it employment, be it civil litigation. As I said clearly, we have, and I have that experience called commercial experience, commercial negotiation skills. I repeat that word again, commercial negotiation skills. They're very important when you're representing either a high-class client or a low-class client, but who want an end to litigation, an end to a claim, or who want a quick exit from the claim or the dispute, be it a contract or be it whatever it is, be it a financial settlement in the family proceedings. They want to settle that and chicken out and don't have time to obey court disclosures and court orders. And sometimes they could be very cumbersome, as a matter of fact, and they can throw up certain things you didn't envisage. So as a result of that, commercial skill is important. And not every practitioner has that commercial skills. I can tell you clearly, because some cases that are running in court today, when I look through to them, they shouldn't actually see the light of a claim form. They should have been resolved before going to the court. But unfortunately, these parties, through their representatives, continue to ride on a case that should be negotiated out of court and settled out of court, either on a win-win basis or a win-lose basis, because there are certain times so you may not achieve a win-win structure in terms of negotiation commercial skill-wise. And also, sometimes you may want to negotiate a win-lose, but you're not actually losing in the real sense of it, because the loss there is really just for you to give and take process, rather than you losing, completely losing in terms of financial or whatever it is. But it will come to the point whereby these offers have been made commercially within two parties to agree, and no parties are not shifting or compromising whatsoever, then litigation becomes the final straw. But however, before you go into the litigation, your case has been prepared. Now, what does this Tice Madox Solicitor will offer? What we'll offer for us is to provide an advice pre-claim form. Pre-claim form, which means on the chances of success in that claim. First of all, we provide an advice and articulate all that before a claim form is finally lodged, which means that we've given what is called a cushioning effect, what we call analysis of your case, and providing what the court will likely be looking at, what the case laws talked about, how we can present this case, how the chances stand from what the other party will be looking at. It's called advice pre-claim form. Advice pre-claim form. With that, your case is clear. The client is now sat down to ask and say, this is the advice we prepared based on your instruction on this. To proceed on this is the chances, this is the weakness, this is the strength. And on that basis, the client can say, I want to go further. Now, in that action, we may also want to go what is called a compromise of negotiation, which is the pre-action protocol or pre-action conduct that I talked about. Ladies and gentlemen, I've been talking civil litigation, and the topic is civil litigation pre-action protocol, which, as I said, has different manners and different procedures. They apply in all these cases. I wish I could go on to explain this. As I said to you, because of a restricted time we have here, is to introduce and bring out your consciousness to seek proper legal advice. And the suppository to Tice Madox Solicitors, when you come before me, I will take time and analyze your case and advise you further. You can check us out on our YouTube pages and subscribe, Tice Madox Solicitors, and all the other social platforms that are showing on your screen, and contact us as well to have a better prospect of your case, whereby we can analyze and prepare it. I cannot overemphasize on the importance of preparation. Just as you want to eat your food, you prepare your meal and you get it ready before you can now light up the gas. This is the way Tice Madox Solicitors will do for you. Prepare your case properly well. in a way that we are ready to run and to achieve success for you in all areas of law: immigration, criminal, and family matters, as I discussed today, civil litigation, and all the areas. You can count on us to achieve your success. Ladies and gentlemen, till next time I come your way, I remain your favorite solicitor, Justice Maduforo, and your favorite firm, Tice Madox Solicitors. And I will say to you again, you do not lose hope. I say that again, do not lose hope. Do not focus on the finances. But what we do for you first is to ensure that your finances are not unnecessarily expended by involving pre-action protocol to ensure cushioning effect of any cost effective that you may want to go into first. Cushion that effect. Bring it down to the barest minimum to the extent that you succeed without hassle. Tice Madox Solicitors is always there for you. Till next time, I say God bless you.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.